everyone. This is Richa Kaur, legal faculty at Manu Law Classes. Today, I will be discussing with you legal GK for the month of June 2021. This is a very important topic for your CLAT exam. In this session, I will be citing some important judgments of Supreme Court, some judgments of High Courts, and some developments that have taken place in the legislative field during this month. Now, before I begin, let me inform you that we have started admissions for our 1 year as well as 2 year courses for all the CLAT aspirants. You can enroll with us today. You can also find out about the same by going on our website www.lawentranceindia.com, or you can call us on 9971 444 054. You may also sign up for a free trial, and during this free trial, you'll be given live access with a one-to-one interaction. You would also be given recorded lectures on various topics. You would be given topic tests, sectional tests, as well as your performance would be analyzed. Now, the process to sign up includes finding the link in the description below. Then you can locate sign up for 15 days free trial. Then you can fill the form and you're all started. Now, moving on, let's start with the first judgment of the Supreme Court. This is a very significant judgment as far as the Insolvency and Bankruptcy Code is concerned. The judgment is called India Resurgence Arc Private Limited versus Amit Metallics Limited and another. Now, in this case, the appellant, by way of a special leave petition, he challenged the resolution plan that had been approved for the insolvency of a corporate debtor called as VSP Udyog Private Limited. Now, the main grievance of the appellant was that against his admitted claim of 13 crore rupees, the resolution plan had offered a meager amount of just 2 crore rupees without considering the valuation of the security that had been held by the appellant over the corporate debtor, which was more than 12 crores. Now, the division bench, it rejected the appeal and it held that it is against the scheme of the Insolvency and Bankruptcy Code to hold that a secured creditor is entitled to an amount in reference to its security interest. Now, if such a situation is permitted, then it would create an inequitable scenario amongst various class of creditors. Therefore, the appellant is entitled to receive an amount not in excess of the receivable liquidation value proposed for the same class of creditors. Moving on to the next judgment. This is Chunni Lal Gaba versus Assistant Director, Directorate of Enforcement. In this case, the Supreme Court has held that an accused has a right to hearing over his bail application. If this right of hearing is denied, it would amount to his infringement of his right to life and liberty that has been guaranteed to him under the Constitution. The Supreme Court also expressed shock over the bail application not being listed for more than a year, even though it was the pandemic time. The court stated that during the pandemic, at least half of the High Court judges should sit on alternate days in order to decide such important matters, which includes bail applications. Moving on to the next judgment. This is Sarina Sarkar and others versus State of Haryana and others. In this case, the Supreme Court has directed the removal of all kinds of encroachments on the Aravali forest land in Faridabad Khori Gaon in Haryana. The court said that there can be no compromise on forest land, as forest land is not an ordinary land and it deals with environment. Also, the court said that the encroachers have to be evicted within a period of 6 weeks from this forest land, and it is the duty of the state to rehabilitate all the slum dwellers that have been residing on this land within the time frame that the court fixes. Now, next is Vishwanath Biradar versus Deepika and others. Now, in this case, the Supreme Court was hearing an appeal that was filed against the order of the High Court of Karnataka, wherein the High Court had rejected the anticipatory bail of the petitioner, which had been granted to it by the Sessions Court in Karnataka. The High Court had also directed the investigating officer, by virtue of this order, to take the accused into custody and to produce him before the concerned jurisdiction court. Now, the Supreme Court, it said that such a direction by the High Court to take the accused into custody is beyond the jurisdiction of the High Court. And it is only the investigating agency who has been entrusted with the investigation to take a call as to whether the accused is liable to be arrested or not on the basis of the material that he has collected during the investigation. And it is not the power of the High Court to make such a direction. Now, the next judgment is Muthulakshmi Swaminathan versus Vijita. This is a judgment that has been passed by the Madras High Court. Now, in this case, the court held that irrespective of whether the proceedings under the Central Act are civil or criminal in nature, Article 227 of the Constitution petition can lie in order to quash the proceedings if a case is really made out. Now, in this case, a petition under 227 was filed to quash the proceedings under the Domestic Violence Act on the file of the judicial magistrate. Now, when this matter came up before the court, the registry had not even numbered the petition. Why? Because such matters used to be heard or decided under Section 482 of CRPC in order to quash proceedings under the Domestic Violence Act. Now, the High Court observed that the text of Article 227 reads as every High Court in India shall have the jurisdiction or shall have power and superintendence over all courts and tribunals in the territories to which it exercises jurisdiction. This text of the provision is forum neutral. It does not make any distinction between civil court or criminal courts. Therefore, it is very clear that Section 482 of CRPC will deal with quashing proceedings which are criminal in nature before the criminal courts. But Article 227 of the Constitution is wider and comprehensive, and therefore it includes both proceedings under civil as well as criminal nature. Moving on to the next judgment. This is V.S. Achyutanandan versus State of Kerala and others. This is a judgment that was recently passed by the Kerala High Court. In this case, the High Court held that a second FIR cannot be registered when the first FIR, based on the same allegations, has already been quashed on merits. The High Court further observed that there can be no fresh investigation on receipt of every subsequent information relating to the same cognizable offense or incident or occurrence. Now, sweeping power of investigation, it does not warrant subjecting a citizen each time to fresh investigation by the police with respect to the same offense. The High Court further observed that it is the duty of the courts to strike a balance between the rights of the citizens under Article 19 and 21 of the Constitution, as well as the expansive power of the police to investigate a cognizable offense. Moving on to the next judgment, this is a Delhi High Court order that was recently passed in the case of Devangana Kalita Asif Iqbal Tanha, Natasha Narwal versus State of NCT, Delhi. This is a very controversial order that was recently passed by the Delhi High Court. In this case, the court was hearing the bail applications of 3 students of Jawaharlal Nehru National University who were accused under the Unlawful Activities Prevention Act. Now, while the court was hearing the bail applications, it said that prima facie, no offense against the accused has been made out under the Unlawful Activities Prevention Act. The students, they were participating in the Citizenship Amendment Act protests, and these protests, they were neither outlawed nor were they banned. These protests, they were being monitored by law enforcement agencies, and the organization that the accused were heading was also not a banned organization. Therefore, there's absolutely no allegation in the charge sheet which would go on to show that the accused had committed any offense under Section 15 of the Unlawful Activities Prevention Act. The charge sheet only highlights that the accused participated in organizing protests, in organizing chakka jams, mobilizing people, instigating people to take part in the Citizenship Amendment Act protests. And these incidents, they are only evidence or they're only proof to show that the 3 accused participated in organizing protests and not they were not a part of any conspiracy to commit a terrorist act or that they committed any form of terrorist act. The court further said that the right to protest is not a terrorist act within the meaning of Unlawful Activities Prevention Act, and terrorist acts under the UAPA only deal with matters impacting the defense of India, and it does not deal with ordinary law and order problems. Now, as soon as this High Court order was passed, the central government approached the Supreme Court in order to get a stay on their bail application. However, the Supreme Court refused to entertain their application and refused to pass a stay. But however, it said that this Delhi High Court order will not serve as a precedent with respect to future cases. Now let's go on to the next judgment. This is Board of Control for Cricket in India versus Deccan Chronicle Holdings Limited. Now this is a judgment which deals with arbitration law, and it was passed by the Bombay High Court. The court, it set aside the High Court set aside the arbitration award passed against BCCI over termination of Deccan charges from Indian Premier League and observed that arbitral tribunal cannot apply public law principles of reasonableness and fairness. The court also said that a private law bound tribunal cannot hold a public body accountable on principles under Article 14 of the Constitution. The court also further said that it is immaterial whether BCCI was a state or whether it was performing public functions, as public law duty cannot be enforced into a contract by a private law arbitral tribunal. The High Court also took objection to the arbitrator applying public law principles to hold that BCCI indulged in unfair discrimination against the Deccan chargers. The court said that the Wednesbury principle of reasonableness is immaterial in a private arbitration dispute, and the commercial arbitrators, they are not entitled to settle a dispute by applying principles what they seem as just, fair, and reasonable. Moving on, let's discuss the legislative developments that have taken place during this period. The first is the Model Tenancy Act that has been passed by the Union Cabinet in order to promote rental housing in the country. Now, this act, it delineates the rights and responsibilities of the landlord and tenant, thereby bridging the trust deficit between the two. Now, this act, it is going to be circulated to all the states and union territories to adopt it by enacting a fresh legislation regarding rental law or by making amendments in their existing rental laws. Now let's discuss the key features of the Act. This Act, it provides for an enhanced rent to be paid by the tenant if the tenant refuses to vacate the tenanted premises even after the expiration of his tenancy. The Act further provides that the security deposit that has to be given by the tenant will be limited to only 2 months' rent in case of a residential tenancy, and it will be limited to 6 months' rent in case of a commercial tenancy. The Act also provides that the landlord, before hiking the rent, he has to give a 3 months notice in writing to the tenant. The Act also provides that any information about the rent agreement has to be given to the rent authority, which shall be a conclusive proof of the same. The Act also provides that the rent tribunal or the rent court has to decide all cases as well as appeals within a period of 60 days in order to prevent any form of harassment to either the landlord or the tenant. Let's go to the next legislative development that has taken place. This is by the government of Karnataka that has given reservation to the transgender persons in its state service. It has amended its state service rules in order to grant reservation to the transgender community. Now, it has decided to provide 1% of vacancies to be filled in any services or post by the state government from among the transgender candidates in each category of general merit, SC, ST, and in each category of other backward classes. Also, every appointing authority will provide a separate column of others along with male and female gender in their application for recruitment to any category of Group A, B, C, or D posts for the convenience of the transgender community. Let's go to the latest development that has been made to the Bar Council of India rules. Now, these rules have been amended and they provide that any criticism and attack of court or a judge or any Bar Council decision by an advocate would amount to a misconduct and would also be a ground for disqualification, suspension, as well as removal of membership from the Bar Council. The amended rules, they read as under that an advocate shall conduct himself or herself as a gentleman or a lady in his or her day-to-day activity, and he shall not do an unlawful act. He or she shall not make any statement in the print, electronic, or social media which is indecent or derogatory or defamatory or motivated or malicious or mischievous against any court or judge or a Bar Council of India or a state bar council. Nor shall any advocate engage in any willful violation, disregard of any order or resolution of Bar Council, and any such conduct shall amount to misconduct, and such advocate would be proceeded against under Section 35 or 36 of the Advocates Act. Now, with this, I come to the end of my lecture. Thank you so much for watching this video. Please stay strong, stay safe, stay protected, and please follow all your COVID protocols. Thank you.